Hi, thanks for joining us from Houston, Texas. This is Reddy and Newman PC. We're live today to answer your immigration questions. My name is Emily Newman. I'm an immigration attorney, been practicing for 15 years, and I'm here with my partner Rahul Reddy.
Hi, this is Rahul Reddy. I'm a founder of Reddy and Newman PC. I've been practicing immigration law for the past 23 years. Our firm has been established in 1997. We do exclusively immigration law. Along with me is my business partner, Emily Newman. We're going to go through some of the questions that have been raised in the Facebook, as we are always there on every Tuesday at 5 o'clock Facebook Live. Thank you for joining us, Emily.
All right, so I guess some of the questions that have been coming up lately, what's going on with the H-1B lottery? Have we started getting any of the return petitions back?
No, not yet. Actually, we have not received a single rejections yet. I don't know why it's taking a longer period of time. Usually...
Actually, it's not longer. Last year we didn't get any until June 15th.
Oh, really?
Yep, I
Okay.
checked it today.
Okay. Probably you update it every time on Immigration Girl, so you probably go back and check your dates, so that will get you the proper dates for you to check on that. So Emily, so we didn't receive until June 15th last time, so we are at the same period as last year, so it's not unusual for us not to receive reject notices. What about have you been receiving any receipt notices now? Is there any hope to receive any receipt notices right now?
We have not received any new receipt notices in over a week now, so I think that process should be done. I will say there were one or two that somehow got lost in the mail, were returned back to USCIS and then remailed to us. So we did get receipts, but they were remailed receipts that we already knew about. And we had actually one case where we never got a receipt, but we got an RFE.
Yeah.
So there's a slight chance of hope if you hadn't heard anything by now, but the majority of everything should have received a receipt at this point.
Yeah, so if you don't, probably the chances of you getting the receipt notice is almost less than 1%. Emily, the biggest deal that is going on right now seems to be that STEM extension, as you already published in immigrationgirl.com and then rnlawgroup.com, that we have noticed that the USCIS has updated its website with regards to what a STEM extension should be and whether the STEM extension person can work at the third-party location. Any updates on that, Emily?
Right, so our question at the time was, when did this get updated? Because there was no announcement. We just saw it happen to be on the USCIS website one day. And how exactly are they going to implement this change? Because they hadn't given any kind of public announcement. Our thought process at the time was maybe we'll start seeing requests for evidence on H-1B petitions asking about the OPT employment, and that in fact has happened.
Yikes, that's not good.
Yeah, so starting this week we've received several requests for evidence specifically for students on the STEM OPT that are placed at third-party work sites. The request for evidence specifically quotes the language from the USCIS website that says that staffing and temp agencies cannot employ STEM OPT workers because they're not the company providing the training. So then the request for evidence gives a list of documents that you can provide to show that you have been complying. But I highly doubt any document you submit is going to be useful. I don't know.
Emily, isn't that the employer should control employee? It's already there in with regards to the implementation of the H-1B. They were already asking the question whether the employer controls the employee. How different it is when we are getting the RFE for STEM extension, where the USCIS is saying that you cannot work at third-party location. But in the H-1B also, they're saying that the employer needs to control employee. How different is this RFE than compared to the regular H-1B RFE?
Well, I think the difference is training versus working. In the STEM OPT, you're still in a training period. You're putting into effect the training plan that you signed, that I-983 form. So it's there in the eyes of the Immigration Service, it's very difficult for you to train someone remotely even though we have online degrees all over the place these days.
Oh, they have drones going and shooting the people out all over the world and remotely controlled. In fact, the Customs and Border Protection, most of the people work at the airports which are not at their location. They are remotely controlled. A lot of things that goes on, particularly in the IT world. It's quite different. But Emily, do you think so? It's going to have a hard time for us to get these approvals right now?
Yeah, I mean, the question is whether this USCIS guidance that was posted on their website can really have the effect of a regulatory change, because the regulation specifically says you just have to be a bona fide employer. It does not go on to say that staffing companies cannot be bona fide employers. USCIS is interpreting that to say that staffing, temp agencies, offsite no longer count as bona fide employers, even though they do for H-1B purposes. But again, I think their reasoning for that is the training aspect versus an H-1B worker who's actually employed is a little bit different.
Bona fide employees is defined by the government of United States, by different departments, by differently. The IRS defines bona fide employment as hire, fire, and pay. But when it comes to USCIS, they put 20 other strings, and they have defined when it comes to OPT differently, when it comes to the H-1 differently. Now, when it comes to the STEM extension, they are defining differently. So this year, we're going to face some hard times for the people who are working at third-party location on the STEM extension. Emily, what if the USCIS does not agree with your argument or with our argument with regards to it's a bona fide employment when we make an argument? What will happen to the H-1B? Will the H-1B will be denied?
Well, the way that the request for evidence is structured, that section is dealing with the status. So it has this title that says beneficiary status, and then underneath it, it says STEM OPT employment third-party offsite placement. So that suggests to me that if they determine that the employer-employee relationship is not being maintained during this training period that's already taken place, they could determine that that is a violation of status. They can still approve the H-1B petition, but they would deny the change of status. That would require the student to then exit the country, apply for a new visa stamp, and then come back October 1st or later. So at this point, I don't expect that it's going to impact the H-1B petition itself. It's a status issue, and each H-1B kind of has two parts to it. It's got the petition part where you've got to prove that the company is an employer and that they're hiring you for a specialty occupation and that you're qualified for the job. And then there's the part about your status. Are you asking to extend your status, change your status, or are you requesting consular processing? So it's the status portion asking the change of status that could be denied.
So according to prediction, even if we get any denial, it's going to be only the I-94. The persons should probably get the H-1B approval. They need to go to India to get the stamping and
or
come
their
back.
home country.
Yes, sorry. Most of the people happens to be Indian, so I get confused in that. Emily, since we are on the topic of the STEM extension, on the CPT, as we have been telling, the day one CPTs are not encouraged, and Radium and PC is always there. Have you received any RFEs right now, those people who are on the CPT, the day one CPT, you know, the CPTs that are granted by the universities, not so-called good universities, and they granted day one CPTs. Is that something, are you seeing any RFEs on that? What do you expect with those things?
Same thing in the beneficiary status section for people who've requested a change of status from F1 to H-1B. We have seen requests where the government will point out that you've had your 12 months of OPT followed by 24 months of STEM OPT, and then you went back to school at the same degree level and now you're in CPT. Prove to us that it's authorized. And while, yes, it may have been authorized by the school in that you received the I-20 and are authorized to work, whether that I-20 was issued properly, was it authorized to be authorized, is another question, because the regulation says that once you've had 12 months of practical training, any kind of practical training, you cannot get another round of practical training at the same degree level. So yes, I do expect that we may see some denial of change of status requests for those that have done the CPT at the same degree level.
Sachin has a very good question, which we both have to refer 2 minutes before we logged into this Facebook, Emily. Is the H-4 EAD regulation submitted to the OMB? And can you also explain what a OMB is and what is going on in the H-4 EAD, what is expected on the H-4 EAD? Because this is the most questioned thing in our thing, where they're asking many questions. Our audiences are asking the questions.
Right. So try to give a long story short here. A long time ago, an executive order was issued that said that every single regulation has to go through OMB approval before the regulation can actually be proposed, before it can be published in the Federal Register. The OMB is the Office of Management and Budget. The purpose of that executive order was to make sure that the differing agencies are all on the same page about who is regulating what, and so there's now conflicts between different agencies and what they're regulating. So it's kind of a big picture look at all of the regulations going on. The OMB has to look at it first. Once they give the approval, then the regulation can be published. Same thing happens once the final regulation is ready to be proposed, I guess finally published. Again, it has to go through the OMB for approval before it can be published and become final. So we're at the stage where we know, according to the court filings, that the government is planning to issue that regulation to OMB so that they can approve it, but they have not done it yet. I checked it just before we logged in. And no, it has not been submitted to the OMB yet. That is publicly available information. You can look it up.
So what does that mean, Emily, that the H-4 EAD regulations, proposed regulations are not out yet, when they're going to be out, when they're going to be implemented? What's going to happen with those people who already have the H-4 EAD? Can they still file the extension, or the extensions that are there are valid right now?
So everything stays as is. You can still file for the first time. You can still get your renewals. Nothing has changed. The reason everyone's asking about it right now is because the latest regulatory agenda that came out suggested that we should have a proposed rule in June. Well, now we're in June. We still don't have a proposed rule, and it hasn't even been submitted to OMB for approval yet. So that, to me, suggests that maybe June was a little
too early?
Because generally the OMB has been taking 30 days or more. I mean, if you look at what is currently with the OMB, all of those proposals have been there for more than 30 days. So it can take some time for them to go through that process. So we may not even see a proposed regulation until July. Once it's proposed, again, remember, the proposal doesn't do anything. It's just something that they plan to do in the future. So even after the proposal happens, we have a published in the Federal Register. You can still apply for your H-4 EAD. You can still get the renewal, replacements, everything you want to do, you can still do. They remain valid. We go through the whole notice and comment period. That can take months, probably 6 to 8 months. And then the government has to review all of those comments, come up with a final rule, still have to give it to OMB one more time for approval, and then they can finally publish a final rule. And then usually that final rule won't take effect for 45 to 60 days. Until that final rule finally takes effect, you can keep filing. There's nothing changing until an actual final rule takes effect. Now, once the final rule does take effect, what happens to existing EADs? Unfortunately, we don't know. That's going to be something that's talked about in the proposal about what the transition period is going to look like. Are they going to allow existing EADs to continue until they expire, which is what our kind of anticipation is, or are they going to say they're not valid from this date going forward? We don't know, and there's no way to know that until they actually issue the final rule.
So Emily, you're telling that a minimum of 4 months if any action can be happening, the final action can be happening, and a maximum of 1-2 years can happen on the H-4 EAD. And while this is going on, you can still apply for the H-4 EAD, you can still apply for the H-4 EAD extension. Based on the historical data, what we have seen with the Trump administration, it is not expected they will just say that, okay, all your EADs are canceled. Most probably our prediction would be that going forward, the further extensions they are not going to extend. That's how they have done with the temporary protected status people belonging to other countries, and also for those undocumented aliens, which are about 800,000 EADs that they have issued. They said they can't further extend it. So still, as Emily has pointed out, it's way down the line. As of now, keep continuing filing those applications.
We have a question for the green card process. What's the difference between filing adjustment of status and filing for consular processing? And which would you choose when you have to check that box on your I-140?
I would, depending on the adjustment of status is filed if the person wants to get the green card in United States. The consular processing is being chosen if the person wants to get the green card in their home country. Typically, we do not recommend people who are here in United States to choose the home country. But there are some situations when we file the green card, when we file the I-140, the individual is outside the country and want to get the green card in the consular processing. At that time, we do pick the column saying that we want to do the consular processing. There are some situations where the person is in United States, Emily, and then we pick the column saying that he's going to adjust, which is that they're going to file the adjustment of status or 485 in United States, but then they tend to leave the country for many other reasons. At that point of time, if we were to change the I-140 application, there is another form called I-824. It's called, we file an I-824 so that the USCIS send the approval to the consulate. So we need to file another application to the consular processing if we don't pick that box. Usually we recommend to pick the box of adjustment of status if the persons are here, and if the persons are outside the country, we pick the box of picking outside in the consulate though.
All right. If someone is on H-1B and they're not being paid properly by their employer, what recourse do they have?
There is a form called W-H-4 on the Department of Labor. I normally recommend clients to go and fill the W-4 form out, send an email to the employer, hey, either you pay me my salary, otherwise I'm going to complain. I normally recommend them doing this one after they move out from that company to another company.
So how do they move out if they don't have any pay stubs?
Well, they can always apply the H-1B, and if they show that they have made a complaint of the W-H-4 form to the Department of Labor, then they will, the USCIS will consider that it's a proper payment. Instead of showing the pay stubs, you can always say the W-H-4. That's a document that you can submit to the Labor Department. So if the W-H-4 is submitted to the Department of Labor, the Department of Labor will go to the employer. 99% of the time they'll go to the employer and will get them the money.
All right. If someone is on H-4 without an EAD, can they do an unpaid internship at a nonprofit organization?
Yes and no. Mostly if it's a nonprofit organization, that looks to be fine. But if it's a for-profit organization, you have to check with your lawyer. If it's a thing like Red Cross or some temple, you're doing some voluntary work, updating the website for the temple or a church or a Red Cross, anything like that, I don't think so it's a major issue. The intention of the person should be not at a future to get the gainful employment. For example, if they're working for a law firm and they're expecting a job at a future date and that is a voluntary job, I think so that's definitely a violation. But if I go and volunteer Red Cross or I go to the Trees Association and trying to plant the tree, I don't intend to get a job as a tree planter there. I'm just volunteering there. It depends on if it's a nonprofit organization, your motive is only to do the temporary job there, not to expect a full-time job there. I don't see that as a problem.
Yeah, and I think you also have to look at whether that job or that internship is something someone else would normally be paid for. So you can't just say, well, I won't take the payment in order for it to be considered volunteer. If it's something that a person would normally get paid for, then I would not do that.
Yeah, that's right. And one issue that I have is that If the person is selected in the lottery and their STEM extension, their OPT is expiring in July, as you already know that if the H1 is selected in the lottery, they are in the cap gap. Do you recommend them to file the STEM extension?
A lot of times I would say yes, as a good backup plan. Number one, if your H-1B is still not approved by October and you filed the STEM extension, then you can work pursuant to the STEM extension while you're waiting for the H-1B to be approved. And number two, in case your H-1B happens to get denied, then you still have the employment authorization through the STEM OPT. The one situation where I might prefer to stick with the cap gap would be if you are doing third-party placement where you're no longer eligible for the STEM OPT. You'd be better off sticking with the cap gap rather than being able to work unless you're able to find another job, and then that could impact your H-1B.
I have moved from location A to location B and it's not in the same MSA. My employer has not filed an amendment. What do I do now?
That's a tough one because once you run into that problem, there's no way to cure it. We see a lot of times in amendment filings or even in extension filings where we'll get a request for evidence asking about the work location and when you started at that location. Wanting to make sure that you're in compliance with that matter of SIMEO guidance. So the difficulty is there's no guidance about what to do in the event that you've messed up and haven't filed the amendment. Probably exiting the country, filing an amendment for consular processing, and then coming back is likely your only option to cure it.
I would require this guy to go in contact and speak with a lawyer privately and one-on-one, though that would be much better. Prema has a question with regards to the H-4 EAD. The H-4 EAD validity is beyond 180 days. Now I am moving from company A to company B. Can I apply for H-4 and H-4 EAD even though it is expiring for more than beyond 180 days? The answer is yes. You can apply for it. As of now, we have not seen a single denial, even though the USCIS says that don't apply the EAD extension if it is within 108, unless it's within 180 days. But in this case, we have seen when you're filing with H-1B and H-4, we have never seen any problem. I would recommend that you go and apply because maybe in future there might be some trouble with regards to the H-4 EAD. I would suggest to go file the H-4 EAD right now.
So have you been noticing any difficulties with certain software jobs and specialty occupation getting H-1B approvals?
Yes, Emily. We have been filing him, a lot of the lawyers, a lot of the companies have been filing H-1Bs for a long period of time. On March 30th or 31st of 2017, the USCIS came with a memo that says that computer programmer may no longer be a specialty occupation. Now, let me explain what a H-1B is. H-1B, the position must require a specific degree as a minimum requirement. That is the requirement of the H-1B. So if the position does not require, then it won't qualify. The USCIS in March 31st has changed a little bit of their version of the computer programmer, but somewhere in October of 2017, the Department of Labor changed its definition with regards to the system analyst version, where they said only 47% of the system analyst position require bachelor's degree. So not only we started getting a lot of RFEs on computer programmers, which normally a lot of lawyers and a lot of companies avoided that even before March of 2007, but from October of 2017, we started getting RFEs and a lot of denials on a system analyst position, which was traditionally approved from the time I've been practicing immigration law from 1995. All of a sudden they turned it. In general, Emily, that we have noticed that in 2017, the specialty occupation, that the degree is a specific requirement for the position, has been getting challenged most of the time, unlike previously what I've been practicing in 1995 all the way to 2016. We haven't seen those many RFEs and those many denials for the specialty occupation. Those troublesome H-1B positions have been computer programmer, computer system analyst recently in 2017.
All right, so we have a question about the 6-year limit for the H-1B, and most of you know under AC 21, if you start your green card process early enough, you can continue to extend beyond the 6-year limit. But what if you didn't start your green card process early enough and your 6-year limit is running out and your labor certification was filed after you entered your sixth year? And what if it gets audited or delayed? Do you have any options to stay beyond the 6-year limit?
If the person has a visa stamping, they can go to India any period of time that they go outside the country and come back in. That's not counted within the 6 years. If they do have an option of converting into H-4, they might want to consider to convert into H-4, and once the I-140 has been approved, they can convert back into the H-1B. So those are some of the options that I can think about, but maybe they need to discuss personally with a lawyer to see how the timing will work out. But please also note that when you go out for the stamping for the H-1B, you're risking yourself in getting back into the country too. Now that raises another question, Emily, is that my H-1B is selected right now. I am an OPT. Can I now travel to India?
Well, in general, we don't recommend travel between April and October when your H-1B is selected, especially if you've requested a change of status from F1 to H1, for example. When you leave the country, you're going to abandon the change of status portion of your petition. So that portion will automatically be denied, meaning you're going to, if the H-1B petition gets approved, it will be without an I-94. So exiting the country will cause consular processing of your petition. But then you also have the problem of when are you planning on coming back, and are you going to be allowed back in if you're not coming back on an H-1B? So you've already given the government your intention that you plan on continuing to stay in the country and work because you filed an H-1B petition, yet you're trying to come in on a student visa, and how are you going to prove your non-immigrant intent when you're coming in on a student visa? It's very possible you may not be allowed back into the country. So just because you could potentially leave doesn't mean you can come back, and even if you do come back, then you've still got to figure out how to get the H-1B status back. There's one other issue I want to point out for F1 students particularly that have the OPT. I've seen recently several times where a student has applied for the H-1B not for change of status, but specifically requested consular processing because they knew they were going to travel and they were going to stay on their OPT or their STEM OPT. They traveled and the H-1B got approved for consular processing, yet the SEVIS record was terminated because the H-1B was approved.
Yikes.
That's happened multiple times, and I just heard another story of it yesterday. This person that I learned about yesterday hadn't traveled. They're still in the country, and because their H-1B got approved, even though it's consular processing, they got a notice that their SEVIS is terminated. They tried to get the I-20 from their school, and they said, nope, you're terminated because your H-1B is approved. So that's something, especially with all this talk about the unlawful presence memo for F1 students, you've really got to keep an eye on your records. Use that SEVP portal, make sure everything is accurate, and make sure that your record is not terminated without your knowledge. It's kind of a scary situation.
Saravanan has a question. Can the H-4 EAD be terminated because the person has changed from company A to company B? H-4 EAD can only be terminated by USCIS. Although in the regulations they pointed out that they will come and issue an intent to revoke if they were to terminate when you move from company A to company B, especially after the regulations of that kicked in January of 2017. I don't think so. H-4 EAD will be terminated just because you move from company A to company B. Particularly if your I-140 has been approved for more than 6 months, I don't think so. There is, and they can do it. I have never seen any of the H-4 EAD getting revoked. Emily, this major question that pops up is: can I convert from EB2 to EB3? It's always been that we have been requested to convert from EB3 to EB2. Now there's a lot of rumors flying around. Can I convert from EB2 to EB3. First, can you explain what is the advantage for some people, if ever it is, and if you can do that?
Right, so yeah, you can do that, and it's based on the visa bulletin with the priority dates, the way they're moving. If EB2 continues to be slowly moving forward and EB3 keeps getting faster and faster, we may get to a point where EB3 is technically faster than EB2. We see that quite often with China. They flip-flop back and forth between EB2 and EB3. So if you are already in EB2, how do you get into EB3? Very likely you can refile or file another I-140 petition using the same labor certification and use that to qualify for the EB3 category if your date is coming current in EB3. Now, one thing to note, if you're using the same labor certification, that means you cannot file in premium processing because you don't have the original. So it will take longer, and it does not have any impact on the existing EB2 approval as well. So unless that gets withdrawn by the company for some reason, the EB2 approval stays valid, and you can file a second one in EB3, and whichever one happens to be faster, proceed with the 485 based on that.
We have done that several times with the Chinese nationals, because with Chinese nationals, sometimes EB2 goes forward, sometimes EB3 goes forward. Yeah, the other point, as Emily is pointing out, is that you can use the same labor certification to convert EB2 into EB3. A lot of times, or most of the times, from converting from EB3 to EB2 requires the company to file one more labor certification. But for converting from EB2 to EB3, mostly, unless there are some rare cases, mostly you do not need to file another labor certification. But please note that, as Emily was pointing out, that you cannot do premium processing, and especially when the reason why she said you can't do premium processing is that we do not submit the original labor certification when we are converting from EB2 to EB3, because we already submitted the original labor certification when we got the EB2 approval. So when we submit the copy of the previous labor certification approval, the USCIS then has to request the Labor Department to get the copy of it from there. That might take a long time. So it might take almost about 1.5 years for the I-140 to approve. But yes, if the EB3 moves forward and your date falls into that particular criteria, I might actually want to file an I-140 and file an adjustment of status and wait for the I-140 approval. But please also note what Emily has said. Just because you got an EB3 from the same labor certification doesn't mean that your EB2 gets away. You can kind of use anything you want. If you have two of those approvals, you can do this, you can do that. Either of those things, whichever is advantage for you.
Have you noticed any trends with the employment-based green card interviews? Are those going pretty smoothly? Anything out of the ordinary?
Yes. Employment previous to March of 2017, mostly 99% of the employment-based green cards were never been interviewed unless there is some issue or randomly they pick some people for interview. But all the applications that were being filed on or after March of 2017 have to go through the adjustment of status interview. As of now, I have not seen any incident that would mark the things. Things are going through smoothly with the interview process, but the time to get the adjustment of status is improving. It's taking a longer time to get the adjustment of status when the priority date is current, but I have not seen anything odd about the interviews right now. Anything? Emily, have you noticed that the FDNS has been kind of the fraud detection unit, have been concentrating more on third-party placement employees and employers? Any development on that you want to update?
Yeah, definitely. We continue to see a rise in the FDNS site visits, and they're happening in lots of different ways now. It's not just a site visit. It might be an email, it might be a phone call, it might be a visit to the office, it might be a visit to the home, it might be a letter sent in the mail requesting documents. So they're definitely stepping up their site visit process and their fraud detection activities.
Mark has a question. My I-140 has been approved, and now I have moved into a higher level position. do I need to file the labor certification I-140 again so that I can get the green card in the same so that I can get the green card? If the position improvement is a natural improvement, gradual and natural improvement, you do not need to file an amendment for the I-140. Now that's not true with the H-1B though, but when it comes to the labor certification I-140, a natural and gradual improvement in the position does not require labor in I-140 to be filed again. Now, if a person has moved from a system analyst position to a CEO position or some very higher level position, that's not a natural improvement in the position. If he's moved from a system analyst or a software developer, he has gone to a manager, that looks to be natural though, but you have to discuss with your lawyer, to your company HR to see if it's a natural and gradual improvement in the job.
All right, I think that answers most of the questions I've seen.
Thank you guys for coming live at 5 o'clock. As usual, Reddy & Newman PC will be live again next Tuesday at 5 p.m. Central Time. Thank you, Emily, for coming and joining. Thank you guys for coming and joining.